My name is William Dale, and I'm an attorney with the law firm of McChesney Dale in Bowie, Maryland. Estate planning is a lifelong process that individuals may undertake from time to time to determine how their assets are to be distributed to and for their loved ones when they die. One of the issues in estate planning that is of concern to people, obviously, is taxes. What taxes apply upon your death to the assets that you've accumulated during your lifetime? Now, we've all heard the terms death taxes, estate taxes, inheritance taxes, and we're all very familiar with income taxes. I'd like to just go through some of the tax issues that may be involved in an estate when someone dies. Now, before death, obviously, on an annual basis, we each have to file individual income tax returns. We may file tax returns jointly with a spouse, or may simply file individual tax returns, both federal tax returns and state tax returns. The federal and state tax returns of someone who dies are due for any income that is earned by that person up through the date of death. Once that person dies, if there are continuing income from that person's assets, then generally that income would be taxed to the person's estate. When a person dies, if there is additional income to be earned following death, it is important to get a new taxpayer identification number for the estate of the person who died. That new tax ID number is the number under which the tax returns for income following death would be filed. The tax return up to date of death would be filed under the person's Social Security number, and if the person was married, it could be a joint return with the person's surviving spouse. Income earned after death, however, would be filed under a fiduciary income tax return using the estate's tax ID number. All of the income is going to be taxed, but only taxed once. It doesn't get taxed both to the person who died and to his estate. Now, if a trust is used, either a revocable trust that came into existence during the person's lifetime, or a testamentary trust, which is a trust that is established by the last will and testament of the person who died, that trust would also have a separate taxpayer identification number and would also file a fiduciary tax return. Now, the tax years for estate tax returns and fiduciary tax returns don't have to be calendar years. They can be fiscal years using other dates based upon the timing of the income. And that's a choice that you can make after consultation with your legal advisor and or financial planner. So income tax returns are necessary when someone dies. But we've also heard of federal estate taxes or state estate taxes. The federal estate tax used to be imposed upon estates that were rather small and were therefore something that required considerable planning. Now, federal estate taxes are not due for estates that are under $5 million, which is a considerably higher threshold than it used to be, and exempts most of us from ever having to worry about those kind of tax returns. And for a couple who have two potential estates, the amount that is exempted is over $10 million. So the federal estate tax return no longer is as important an issue to be planned for as it used to be. Now, obviously, if you happen to have an estate that is in the neighborhood of $5 million or more, then you need to do some tax planning, and it's very important to make sure you consult with legal counsel and your accountant to take whatever planning avenues are available. The state estate tax return, however, can be imposed with a significantly smaller estate. For example, in the state of Maryland, as of the current time in 2013, estates of $1 million and over are subject to tax. The tax rate is 16%. So an estate in the amount of $2 million is potentially subject to a $160,000 tax payment. This is an important issue that needs to be addressed when you're doing your estate planning, to at least put off as long as possible payment of Maryland estate taxes, or avoid them altogether if that's possible. And again, it's important to consult with your tax advisor to accomplish this. Now, the term inheritance tax is a tax that's imposed upon the receipt of property from an estate. So if a beneficiary receives a distribution, they may be subject to inheritance taxes. Inheritance and estate taxes differ state by state. In Maryland, there is no longer an inheritance tax if you are a direct descendant of the person who died. So either a spouse or children, grandchildren of the person who died do not have to pay any inheritance tax in Maryland. There is a tax in the amount of 10% of the amount received for collateral heirs. So if you receive assets from an estate of an aunt or an uncle, those would be subject to inheritance tax. Or if you're not related to the person who died at all, that would be subject to inheritance tax as well. Again, this is something that may require some careful planning and can be avoided in certain circumstances if it is a considerable amount. Now, one piece of good news about taxes is that capital gains taxes use something called a stepped-up basis. As you are aware, during your lifetime, if you have a capital asset like stock or real estate or your house, other capital assets, and those assets appreciate in value, you have to pay capital gains taxes upon the profit you make when you sell that asset. Now, there are some exemptions, like for a personal residence. Some of the capital gains can be shielded. But when a person dies, the recipient of the property will receive a new basis, basis being the sort of the purchase price value for purposes of calculating whether or not you have a gain. That new basis for the recipient of the property is the fair market value as of date of death. That means that if someone who holds highly appreciated property holds it until their death, their heirs can turn around and sell it after death and do not have to pay capital gains taxes unless there's been more appreciation after death. This is a way that capital gains taxes can be avoided. Rather than selling property during your lifetime, you leave it to your heirs and they can avoid the capital gains taxes. In general, the issue of taxes is an important issue to plan around when you're doing your estate planning. But it shouldn't be an area of terrible concern unless you happen to have a significantly larger estate. But in any circumstance, it's important to meet with your tax advisor, your attorney, to discuss the potential tax implications of your estate or your parents' estate or your children's estate in order to make sure that any planning that is available can be undertaken. Thank you for your time.